Dear fellow Canadians, my name is Ahmer Nadeem Memon. I live in Calgary, Alberta. I am president of Indus Association of Canada, which is a cultural and a charity organization. As we all know, Canadian elections are scheduled on 19th October, and there is a much talk going on about Bill C-51 and C-24. I thought to do some homework and find out what is it about, and I realized that there are some grave concerns and gray areas which are not cleared in that bill. So I thought to share it with you guys because then you can make your judgment accordingly. First of all, let me talk about Bill C-51. The bill, though, is not about terrorism. It's about granting greater powers to police authorities to target activities that could undermine the security of Canada, as well as activities that are detrimental to Canada's interest. The current anti-terrorism section 8301 of the Criminal Code already contains 14th broadly worded terrorism-related offenses for a terrorism activity and contains provisions for preventive arrest, preventive detention, and preventive restraints for prosecuting and punishing crimes that have been committed already, and only after those offenses have been proven by the prosecution beyond a reasonable doubt. Bill C-51 would allow law enforcement agencies to arrest somebody if they suspect that a terrorist act may be carried out, instead of the current standard of will be carried out. Mark the difference. I give you an example. 6 youth adults stand in front of a church or gurdwara or mosque late at night in heated discussion in some foreign language. They may be debating the merits of a new Drake album. They may be talking about video or sports, or girls, or educating the overthrow of Harper government. Who knows? There is no evidence one way or the other, but the new standard for arrest and detention, reason to suspect that they may commit an act, is so low that an officer could act on mere suspicion that an arrest is likely to prevent any terrorist activities. Another truly bizarre aspect of the new offense is the use of term terrorism offenses. The new offense is meant to include speech promoting and advocating terrorism in general, a deliberately opaque and unknowable term. The proposed new offense can also be applied to statements made in private. Now, after C-51, students will think twice before posting an article on Facebook questioning military action against insurgents overseas. Journalists will be wary of questioning government decisions to add groups to Canada's list of terrorist entities and so on. Both changes result in a significant lowering of standards for arrest and detention. Now coming to the Bill C-24. At the beginning of June, the very nature of Canadian citizenship was altered as a major portion of Bill C-24 went into effect, creating a two-tier citizenship system. As a result of this new law, dual citizens and people who have immigrated to Canada can have their citizenship taken away while other Canadians cannot. We have the benefit of a modern judicial process that includes prosecution, trial before an independent judge, and in the event of conviction, a just punishment that achieves the goals of deterrence. We do not need to throw Canada back to the dark ages and revive the medieval practices of banishment as a way of punishing people. And once we make it lawful to exile some people, what to stop it being used against others in future? Under Canada's previous laws, citizenship could only be removed after a hearing before a judge. Under the new law, the minister will, in most cases, make the decision without a hearing. Bill C-24 intends to remove the right of citizens to appeal to the courts. Bill C-24 proposes to give the Minister of Citizenship and Immigration the authority to strip dual nationals of Canadian citizenship if they commit the offense or prohibited conduct referred to in the bill. But it is not the job of elected officials and government bureaucrats to punish people for such acts. Canadian law already has established mechanisms by which to punish criminal wrongdoers. Also, the new law introduces a requirement that persons who apply for citizenship must show intent to reside in Canada after they obtain the citizenship. The new law empowers government officials to speculate on an application's future intentions and then potentially deny them citizenship on the basis of that conjecture. Without a shred of evidence, if they believe citizen did not have the intention to live in Canada when they applied for citizenship. This means that Canadian citizens could be stripped of their citizenship without hearing if they move to another country to be with a dying relative, or to live with their children, or to pursue a business, academic, or other employment opportunities for supposedly misrepresenting their intention to reside in Canada when they were granted the citizenship. The citizenship stripping has been unconstitutional in the United States for over 50 years. The words of United States Chief Justice Earl Warren remains as true today as they were in 1958. Citizenship is not a license that expires upon misbehavior, and the deprivation of citizenship is not a weapon that the governments may use to express its displeasures at a citizen's conduct, however reprehensible that conduct may be. In fact, the courts have recognized that taking away citizenship is a violation of a person's constitutional rights. I would request you to kindly exercise your vote after giving a thorough consideration of these bills as we just discussed. Thank you very much. Long live multiculturalism. Long live Canada.